Wills and Trusts question from July 2001 is another one of those short fact patterns that can tend to be rather problematic. Now, as it turns out, this is a simple question. It's a straightforward question. It's testing very common issues on California Bar Wills and Trusts problems. So if you're one of those many students who are learning Wills and Trusts law by doing a lot of essay questions, this will be very helpful to you. And for those of you who think you already know the law pretty well, we'll find out just how true that is. Take a look at the call of the question. It asks, what interests, if any, do Deb, Sam, Ann, Beth, and Carl have in Ted's estate and or trust? Discuss according to California law. All right, fair enough. Now, the shoot from the hip approach to answering this problem would be to organize our answer around these beneficiaries, and that would be a virtually suicidal move. Remember, anytime we're dealing with wills and trusts, our first step is to establish the validity or invalidity of any of the documents that are involved. Then we turn to the beneficiaries. So, here, as you will soon see, we need to do a fair amount of analysis up front before we can get to the distribution issues. So let's do it. Let's go to the top of the question and review the facts as they were presented to us. In paragraph 1, we meet Ted, a widower who has a child, Deb. He's also got 3 brothers, Abe, Bob, and Carl. And we can anticipate lapse and anti-lapse issues already. In paragraph 2, Abe dies in 1998. He is survived by his child, Ann. Ted then gets a letter from a woman he once had a relationship with. The letter states that Ted has a son and that the son had been born in 1997, and this child is named Sam. Up until then, Ted was not aware of Sam's existence. He writes back saying he doubts he is Sam's father. In paragraph 3, Ted executes a will in 1999, and there's only one witness, so it would fail as a witnessed will. But be careful. Everything except the signature of that sole witness is in Ted's own handwriting. So, almost certainly, this document will be admitted to probate in California as a valid holograph. Let's look at the terms of this will. Half of the estate is to be held in trust by Trustee Inc. for 10 years, with the income to be paid annually, quote unquote, to my brothers, with the principal at the end of 10 years to go to my child, Deb. The other half of the estate is supposed to go to Deb outright. A month after he signs the will, Ted's second brother, Bob, dies, survived by Beth. Now, the lapse and anti-lapse issues come to the fore. Ted dies in 2000. After he's dead, DNA testing confirms paternity. Ted is Sam's father. So Sam is an omitted child, and if you're a little sharp on the black letter law, you know that Sam is going to take half of Ted's estate up front. He is entitled to his intestate share. Then we get the call of the question again. What interests, if any, do Deb, Sam, Ann, Beth, and Carl have? Okay, fair enough. Well, turn the page and take a look at the outline of issues that I present. And I think you'll see, as is usually the case, the outline that I offer for your consideration is intuitively sensible. And also, it sets up well if we want to present a thorough, detailed answer under time pressures. So first, we establish the validity of Ted's will. And here, I'm just following the basic approach that law students learn and that we use for all bar exam purposes. Capacity, intent, formalities. The bottom line is Ted's will is invalid as a witnessed formal document, but it will be admitted to probate as a valid holograph. All right, that's very simple analysis, and as you'll see if you haven't looked already, it doesn't take much time to carry it through. But it is a necessary first step to establish the validity of the will in order to proceed to explain how the distribution will go. So, with regard to distribution, I start off by reciting the terms of Ted's will. And here I incorporate the analysis to establish the validity of the trust. So even in the outline, I indicate that we've got to talk about the settlor, the trustee, the beneficiaries, the purpose, the corpus. Next, we have 50% going to Deb. Next, we contend with the material facts that intrude on our analysis of the will. First, Abe dies in 1998. It's before the will was executed. Therefore, no lapse protection. In 1999, Bob dies, survived by Beth, and she'll be covered by the lapse and anti-lapse laws. Next, we discover that Sam is Ted's son. He is an omitted child, and he gets his intestate share. Then, only when we reach the conclusions do I actually answer the question presented by the call of the question. I give Sam 50% up front. I give Deb half now, and the trust residuary, half of what remains, now, that is, and gets nothing because she's not protected. Beth and Carl each get half of the trust income for 10 years. It's simple enough, but you've got to know the law well, and you've got to know essay techniques well to organize your answer in such a fashion as to allow you to display to the grader your knowledge both of the law and your appreciation of the facts. Now, briefly, let's review the answer that I present. We start off with a consideration of Ted's will. Notice I lead with the facts up front, and also I acknowledge that we can't answer the question presented until we examine both the will and the other facts involving all of the parties. So, first I start off with capacity. I don't waste much time with it because it's obvious capacity is present. Next, intent also is plainly established. I deal with it in a total of one sentence. Then formalities is the more complicated section. This takes me 3 or 4 sentences. Ultimately, I conclude that Ted's will gets probated because it is a valid holograph, not because of its status as a valid witness will, which it is not. Then we focus on distribution. But here again, we can't just answer the question directly. We have to do some analysis first. So we consider the terms of the will. And here I focus on the trust. And you'll notice I find a home for the law about what it takes to have a valid trust. We've got a settlor, a trustee, beneficiaries, and a corpus. Also, we've got a residuary beneficiary, Deb. So all of this appears to be legitimate to me. Next, we focus on the material facts. And here we're dealing with the death of Abe and the death of Bob. And as I've already indicated earlier in this commentary, Abe died before the will, and therefore Anne is not protected by the lapse and anti-lapse statute. In 1999, after the will is created, Bob dies, and Beth, his daughter, is protected by lapse and anti-lapse. Next, we consider the omitted child, Sam, and here I do the analysis quickly, but I do find a home for all of the facts and the key fact that Ted was unaware that Sam was his son at the time he executed his will. That dictates the result. So, finally, we turn to the conclusion, which is the straight answer to the question presented by the call. Sam, as an omitted child, gets 50% of the estate, because that's his intestate share. Next, Deb, who was provided for under the will take 50% of what remains of her father's estate after Sam's share is deducted. Then Deb gets the corpus of the testamentary trust. Anne takes nothing because her father predeceased Ted. Beth gets 50% of the trust income for 10 years because Beth was Bob's daughter, and Beth is protected by the anti-lapse statute. Carl is Ted's other brother, the only survivor amongst the brothers. He gets the other half of the trust income during the 10 years. And that wraps up a consideration of a very straightforward and a very conventional wills and trusts fact pattern. If you're looking at this question to learn some law, I'm sure the question did its job.